Everybody. My name is Sheree Hoffman, and I am from Memphis. I practice in the western section of Tennessee, obviously. And to tell you a little bit about myself, briefly, I've been practicing law for 30 years. About 25 of those years have been primarily in the area of family law, and this is sort of a weird setup because I feel like I'm moving around and having to look right and left. I am a litigator. I have a mediation practice. My firm is called the Hoffman Law and Mediation Office. And I also do collaborative law. My preference is not to litigate. I think there's a right way and a wrong way to get divorced, and the wrong way is probably to end up in court. So my goal for my clients is to stay out of court whenever possible. I know it's 4 o'clock on Friday. I've already been in this room for the prior CLE, and I saw a lot of people yawning. So I'm going to, this is your second full day of CLE, so I'm going to try to get through this as quickly as possible, and I've actually been given permission to finish early. So I'm going to rush through. I promise not to go 1 second past 5 o'clock, and I'll try to get everybody out of here early. Do we have anybody in the room who actually practices family law? Yay. Feel free to, to tell us about your experiences and to offer any other advice you would like to. I like for my CLEs to be interactive, so to the degree that can happen, please feel free to raise your hand and ask questions or just yell something out, as long as it's appropriate. The documents that you have in your book are really not what I'm getting ready to show you. I've made some changes, and so you might want to just watch your TV screens. And let's get started. Okay, a brief history of divorce. I'm going to try to make this, divorce is not a really funny topic, but I will try to make it as entertaining and informative as I can. And I know if I stand here, is it bad? Okay, brief history of divorce. We all know that initially divorce could only be granted by the church, and it was really in very rare circumstances. 1527, the great Henry VIII infamously requested that the church grant him a divorce, and we all know about that story, so he could marry his mistress. The church declined, but he married his mistress anyway. And that was sort of the beginning of our real history of divorce in the world. During the 17th and 18th centuries, adultery became an accepted and commonly used ground for divorce and was really the only ground for divorce. In 1857, there was a document called the Matrimonial Causes Act, and that became the first divorce law. Unfortunately, or fortunately, it only allowed men to petition the court for a divorce. The act didn't apply to women at all. Then, in 1923, women were finally able to also petition the court for a divorce. So since the 1960s, when social policies became a little more liberal, the divorce rate has steadily increased. Latest statistics on divorce. Interestingly, you will find, if you just Google this, you will find all kinds of statistics, and none of them really are accurate. Most of them are not accurate. We commonly hear that 50% of marriages end in divorce. According to the CDC, and this is as of 2012, that's not true. Amazingly, I wonder how we all prosper as divorce lawyers now. But anyway, 50% of all marriages do not end in divorce, and the divorce rate per 1,000 people is actually only 3.6, which is amazing to me. I didn't know that. First marriages, 20% end within the first 5 years, 33% after 10 years. I always heard about the 7-year itch, so I don't know where that fits in right there between 20 and 33%. Second marriages, we've all heard that second marriages have a higher divorce rate, and that apparently is true. Okay, what do you guys think the main causes for divorce are? That's a good one, that's for sure. Okay, here we go. Again, if you look at the documents that have been provided for you, when I did a little more research, this is a 2012. What you have in your materials is 2004. So look at how it's changed. Number one, falling out of love. I don't know what that means. That could be a million different things. Extramarital affair, we know what that is. Midlife crisis, I'm not sure what that means either. We probably all go through that at some point, except for those of you who are really young. Financial money worries, of course, a huge reason for divorce. I can't tell you how many divorces I've seen from people who are building a house, talking about construction law, that was the earlier CLE. That might be also down under stressors. Family strains, obviously. Children are a big cause of divorce, not causing the divorce, but children's issues, different styles of parenting. Workaholism, 5%, and then stress, and I put the practice of law because we all know that we are in a very stressful profession, and among lawyers, the divorce rate is really very high. All right, number one reason for divorce. This is my number one reason for divorce after practicing for 25 years, poor communication skills. People do not know how to communicate with each other productively. It's a learned art. It's not something that we're born knowing how to do. And you've seen, probably in the past 5, maybe even 10 years, an explosion of a field called communication coaches. And that's simply people who teach other people how to communicate well. I don't think my parents communicated that well, quite frankly. My mother would slam doors when she got mad, and my father would scream and yell. He was a lawyer, by the way. And, you know, you learn from your parents how to communicate in relationships. And sadly, it's usually not a very good experience. Or they're not very good teachers. Okay, this is the reality. A good marriage does not require a perfect man or a perfect woman, and that's a good thing because none of us are perfect at all. 4 major areas of dispute. TCA 364-101 is the divorce statute. I mean, it's got everything in there that you pretty much need to know about divorce. But the 4 areas we deal with are property division, spousal support, parenting schedules, and child support. I know that there's already been a CLE either earlier today or yesterday, on child support, so I'm not going to spend a lot of time on that. Property division, those are some of the issues that come up. Is it separate property, marital property? Marital property is anything that is accumulated during the marriage. Separate property could be something that is you bring into the marriage. It could perhaps be an inheritance, but you know, there are other issues about that too. I have to say that when they called me to speak, I asked about speaking on a topic that wasn't quite so broad relating to divorce, and they specifically asked me to speak about generic divorce and all the, you know, what happens when you file for divorce and what are the issues. So that's what I'm trying to do today. Valuation issues are huge. You can get appraisals. There's always disputes about how much the house is worth, how much the guns are worth, how much, you know, the cars are worth. We're going through a case right now where we have spent a lot of money having tools appraised. The husband is a mechanic and has major tools that, you know, are worth substantial amounts of money. Okay.
Just a quick question. I can see some of that, but I mean, things that establish values, like cars have blue book values. How does that become?
Well, most of the time you can come to some kind of an agreement on those issues, but you may have an antique car or something like that. And that's going to require an expert coming in and valuing it if the parties can't agree. Okay, the very beginning of divorce, as somebody said, the cause of divorce is marriage. That's true. So you want to, if you decide to come into this area of the practice, and my husband is sitting back in the back, I see, he very affectionately tells me that he would rather shoot himself than be a family law attorney. But prenups. The biggest issues when you're talking about drafting prenups, again, it's just a contract, but you have to have disclosure, you have to have independent representation, and of course no coercion. You can't sign your prenup the day of the marriage or the day of the wedding. So those are the types of issues that come up there, and people are very negative about prenups, which I don't understand, and I've tried to dispel this because marriage is a business relationship, like it or not. The objections you're going to hear are, we're too young, we don't have any money, or we're in love, and we don't need a prenup. So I think that, it's a good idea for people to at least have this conversation. And I don't even care how young you are, whether you don't have, any money. It forces you to talk about these issues. And most people, very similar to child rearing. When you get married, oftentimes you don't talk about how you want to raise your children and the differences you may have in that regard. It's the same with money. People don't really sit down and have conversations about what kind of spender are you? Are you a saver? Are you a spender? And those kinds of things are what destroy marriages. They easily destroy marriages. So it's great to have prenups, and even if you ultimately don't enter into one, it's good to have the discussion. And you can fashion your prenup to say anything you want, just like any other contract. It doesn't have to be, my husband's getting everything and I'm getting nothing. Okay, domestic partner agreements. If you're not jumping on this LGBT bandwagon and you're a family law attorney, then you are missing out, because it is going to be an important part of your practice. Oops. Okay, and then here's grounds. Those are all the grounds. And these are the two I've bolded are the two that we see most common. Inappropriate marital conduct, which can pretty much be just about anything that happens, especially in a long-term marriage. And irreconcilable differences is our uncontested ground. Process of divorce, you file your complaint for legal separation or divorce. I couldn't resist I had to put this quote in here. The difference between a divorce and a legal separation is that a legal separation gives the husband time to hide his money. That's a very sexist quote, by the way, and I don't intend for it to be, but that's the actual quote. It could be, wife, time to hide her money. But I thought it was cute, and I miss Johnny Carson. Statutory, mandatory, automatic injunctions. People don't pay enough attention to these. That is, when you file your complaint for divorce, assuming that you've alleged some contested grounds, there's an automatic mandatory injunction that immediately attaches, which keeps you from dissipating assets, selling cars, going to Tunica and gambling the money away, or changing life insurance policies, the beneficiary, changing health insurance policies. It's very, very important in a divorce situation. It's also the cause for some real litigated issues. Petitions for contempt are filed over this because somebody takes money out of a retirement account, for example, while this is pending without permission of the other party. I'm involved in a case right now where a client took money out of the retirement account and paid some school tuition and some other marital bills. The statute says you can keep paying normal bills out of your current income, but you can't use any other marital assets to do that. So that's going to be an issue for us. Dissipation of marital assets, adultery, how much money has one party spent on their paramour, gambling, poor investment choices even. I had a situation where the husband had a financial background and the wife had a lot of separate assets which she had allowed him. There's a dispute about whether she allowed him to do this, but he had invested her money and lost a substantial part of it. So that was a big issue. And then, of course, attorney fees. I put attorney fees down there because there is a big discussion in Shelby County right now about amending this mandatory injunction to allow people to go to accounts and pay attorney fees. The reason for that is you have a situation where a wife whose father is paying all of her attorney fees, and she has $60,000 worth of attorney fees, but the husband is trying to pay his attorney fees and trying to respond to all of the discovery and all of the motions and all of the litigation by paying for that out of current income, which just gets him on his regular bills, as they say, behind her. So it's a problem when one party has access to money to pay attorney fees and the other party does not. Okay, discovery. I think discovery has gone crazy, absolutely gone crazy, and I hate it. But I grew up with a father who he was a personal injury plaintiff's attorney, and he literally could try a jury case, maybe 2, in a day. And he went to court with a file that was about that big. And you don't see that anymore. Now, what do you see? People walking in for a lot of different cases, but in divorce cases especially. If there's a trial and divorce case, I promise you, they're going to be lugging behind them a big old suitcase full of files with all kinds of documents in it. And if you're in a small firm like I am, it's me and my associate, paralegal, and a clerk, then you can spend hours and hours and hours documenting, organizing discovery documents. We receive and we give documents on CDs now. You're talking about sometimes hundreds of documents, maybe 1,000 documents. And it's just, it's really, at some point, overwhelming, hard to do. But it's sort of a necessary evil if you're involved in a case that is just, you cannot keep out of court and is just going to get litigated. Marital dissolution agreements, that is the document that both parties have to sign if you're going to have an uncontested divorce. And it addresses all of these issues: personal property, bank accounts, businesses that one party or the other may own, insurance, life and health insurance, real property, are you going to sell the house, keep the house, refinance the house, debt issues, taxes, and, sometimes restraining provisions. It's pretty common now to have a restraining provision in all MDAs that say, you agree not to harass each other after the divorce, basically. Okay, retirement accounts are usually divided by qualified domestic relations order, separate order from any of these other issues in a divorce that the judge signs, and it will divide your 401ks or your pension plans. When that happens and when that is when that is done, there are no penalties for division of your retirement accounts or withdrawal, transfer of the accounts to the spouse. So that's helpful. And that's a whole nother CLE too, qualified domestic relations orders. Alimony, need and ability to pay, the two determining factors for whether or not somebody gets alimony and whether or not somebody pays alimony. And we use, I think I put in your documents, there is a sample of what we use to list assets and debt. And, that sort of tells us what the marital estate is worth. When we're dealing with alimony, we do income and expense statements, monthly income and expense statements, so that at the end of that, when you've listed all of your payments and what your gross and your net income is, you either have a deficit at the end of the month or you have a surplus at the end of the month. And it's really not rocket science. Go ahead.
What if you have one of the spouses is hiding money, let's say, for instance, and he owns his own company. He hasn't filed income tax returns in 2 years. And you have no way to prove what his ability to pay is. He says he's broke, but yet he lives a lifestyle that exhibits he isn't. How do you deal with that?
You withdraw from that case. No, I'm kidding. You don't. But it's very difficult. I mean, it just is. I mean, you don't want to throw good money after bad. So, most of the time, if you're really looking at bank accounts, you subpoena bank accounts, you subpoena credit cards, and that's what I mean about, you'll spend hours and hours trying to find the hidden assets. And sometimes you can, but sometimes you can't.
What about the income tax returns? Is there any way to force him to, he hadn't filed for business or personal?
Well, I've had spouses call the IRS. And so, I don't know what the other spouse has been doing. Has the other spouse been filing separately? So, it's sort of a problem for she or he who has been, who's participated in that.
But there's no way to see what his income, he's not.
Well, again, the best way to do that is just to subpoena bank accounts. And credit cards and things like, like that, because then you see what deposits are being made. And I talk about in a minute, I'm going to talk about doing summaries for trial, which are so helpful in these kinds of cases where you may have, like, let's say somebody travels a lot in their workplace and they're getting business reimbursements, but they're not depositing the business reimbursements, and they're putting perhaps putting the charges on a credit card, but they're not taking the business reimbursement and depositing it back into the account, or they're not paying off the credit card with that money. So, those are the kind of things that I think you can bring to the court's attention, or to a mediator's attention, or to in a collaborative law case, and have discussions about, because those things will sort of indicate that something's not right. Where's that money going? Okay, then we have, this is the Tennessee Supreme Court case on alimony, and it is, if you're interested in alimony, it's a fabulous case to read, because they have a whole legislative discussion about the legislative history of alimony in general and all the different types of alimony in Tennessee. And by the way, since you don't have this PowerPoint, if anybody wants it, I'll just email it to you. So I'm sure that I'll have in about 15 minutes this rash of people wanting this PowerPoint. But okay, permanent parenting plans. In 2005, since 2005, we now have a standard permanent parenting plan form. And during that time, there was a whole big discussion about how to make divorce better for people. Less antagonistic, better for children primarily. And one of the things that came out of that was to try and not use the word custody. Now we say parenting time, because custody is a fighting word, and I think that was a great move. Parenting schedules, what the permanent parenting plan does is you determine, what's going to be the day-to-day schedule. Standard parenting time used to be every other weekend, 2 weeks in the summer, alternating holidays, and you just don't see that so much anymore. There's much more of a push and a movement and an acceptance of both parties seeing the children more frequently. Obviously, the whole point of the parenting plan is to look out for the best interests of the children. I'm not sure about in Nashville. Most of the time in Shelby County and Tipton and Fayette, when you walk in with a permanent parenting plan, it means that you have an uncontested divorce unless you're submitting a proposal for a trial. So if you have an uncontested divorce and both parties have signed off on a parenting plan, the odds are you're going to hear 2 words from the judge, and that's good job. Because A, they don't have to worry about this case anymore, and B, they're not being asked to make decisions about somebody else's children, which from my perspective is a horrible thing for parents to allow to happen anyway. Okay, primary residential parent used to be called the custodial parent. However, I always tell my clients it's not something to argue about. The primary residential parent is simply the parent who spends 1 day more during a year with the children. So I'm not going to allow my clients, and hopefully be able to ratchet down any arguments about that with the other party as well. Sometimes we even have joint residential parents where both parents are named as residential parents. This becomes important for a number of reasons. It becomes important in terms of child support because the number of days that each parent has does have an effect on child support. It also may become important with regard to public schools. So in Shelby County, the parent who is designated the primary residential parent is the parent. That residence is where those children will qualify to go to school. I see a lot more 50-50 parenting time schedules now than I have ever seen before. Move-away cases, some of the hardest cases that we have are move-away cases. One parent, the parent who is a residential parent, decides to move away for a number of different reasons. It could be, she gets or he gets remarried and one spouse has to move for a job. We have such a mobile society these days. Or it could be that one spouse wants to keep the children away from the other parent, in which case, those are two very different scenarios. And again, how many days each parent has is a factor in determining how the court will handle these cases if it gets to court and what the determination will ultimately be. That's also another CLE in and of itself. We do have a new parenting plan form, and this is the website for it. If you don't have it and you want it, you can download it. The only change in the whole plan, and it's about it's a 13-page document, is that they have changed from 100 miles to 50 miles the move-away notice, meaning if you move your children, if you're the residential parent and you move your children more than 50 miles away or out of state, then you have to give notice to the other parent. And I'm going to talk a little bit more about that. Well, I'm going to talk about it right now because here it is. This case, which is a very recent case, said 2012 held that when somebody sends you written notice, you're supposed to send certified mail notice that you're moving with the kids. The other parent then has 30 days to respond. In this case, held that 30-day response time is mandatory. There's no, well, I was only 2 days late or whatever. In this particular case, the father told the mother verbally that he did not want her to move and he was opposed to it. But he didn't file his petition until about 32 days after he'd received the notice. And the court allowed her to move. Okay, child support guidelines. I'm not going to get into that too much except for to say we have guidelines, and it's a computer program. Based on the two primary issues that are debated when you're trying to arrive at a child support figure are gross income, and there's a specific definition of what gross income is that includes a list of a number of things, and the days of the parenting time. The more time you have, that both parties have with the children, or the more time the non-residential parent has with the children, the less child support that parent will pay. And it makes sense because the more time you have with the children, the more money you're spending on the children. Pendenti or temporary support hearings, common. We have them all the time. I was in one yesterday until about 6 o'clock at night. Sometimes they're just necessary because one parent or the other refuses to pay support. Prepare summaries for hearings. That's what I was talking about earlier. It's very, very important. Tennessee Rules of Evidence allow you to prepare a summary of what your documents are. If you're not using this, you're making your life harder than it needs to be. Because if you're talking about wanting to know, for instance, what we were talking about before, deposits into accounts, and business reimbursement checks, make a summary of that. Otherwise, what do you have to do? You have to look at bank statements. And the judge didn't want to do that. Nobody wants to do that. So these summaries can be very, very helpful and can be the difference between whether you win or lose your case, in my opinion. Okay, process, let's see. Guardian ad litems, Tennessee Supreme Court Rule 40, and that's the statute that deals with this. Guardian ad litems are still appointed. They're not appointed quite as much as they used to be, because Tennessee, the Rule 40 now pretty much takes away a lot of the power that a guardian ad litem used to have. And that's a whole nother CLE on its own, too. But suffice it to say, in our juvenile court, they're still used pretty frequently, but not so much in divorce cases. Okay, court-ordered psychological evaluations. We have new rules about mental health records I'm going to tell you about in a second. Domestic violence and protective orders. I seem to be seeing a lot of domestic violence cases now, I'm sorry to say. And I would advise you that if you're going into divorce court to ask for a protective order, we have two tracks you can take. An individual can go and ask for a protective order in our General Sessions criminal courts in Shelby County. And then, once they hear that there's a divorce pending or a divorce is filed, they will shift that to circuit court or chancery court where our divorces are heard. So, if you're initially going into circuit court for a protective order, you can use that opportunity to have the judge order a number of things. If the judge finds that a protective order is necessary, I've had cases where the judge also ordered, at that time, obviously anger management, has ordered, in one case, she ordered the defendant to produce medical records, and so you can, if you're needing other things during that hearing, that's the time to ask for them. You may not get everything you want, but if you don't ask, you don't get anything. Grandparents' rights, a whole nother CLE on that as well. That's the statute that affects grandparents' rights, and I'm glad to see things changing so that grandparents' relationships with their grandchildren are being honored. I think there's still ways we can go with that, but at least it's not too bad, so sad for the grandparents anymore. Postnuptial agreements, just like prenups. I have seen situations where, and written many postnup agreements, typically you see that when a party, let's say there's been a betrayal, and there's adultery issue, and the parties then decide, they file for divorce, one party files for divorce, and then they decide to not to get divorced, to try to reconcile and save the marriage. Before that, you can draft a postnuptial agreement that essentially says, okay, if we end up getting divorced 10 years from now or 5 years from now, then I agree to give you such and such. So there's no arguing about it. I say that, but hopefully it cuts down on the arguing about what is going to happen when that divorce occurs, if it occurs. So it's sort of a little insurance policy for the innocent spouse, I guess, to try to make the marriage work. And I think more often than not, that's probably a good thing. Here is the case, Bratton versus Bratton is the case where the Supreme Court said it is not contrary to public policy to have postnuptial agreements as long as you have consideration, it's been however you say that word, entered into, no fraud, duress, or coercion. Same thing as with any contract, and same thing as with prenups. Okay, negotiations. We do settlement conferences all the time with judges and without judges. Sometimes the attorneys will just get together with their clients and try to work issues out in what we call settlement conferences. Mediation, I say, is the greatest thing since sliced bread. Love it. Been doing it since 1992, way before there was a Tennessee Supreme Court rule, way before there were any rules, as a matter of fact, about it. And I think it's absolutely a wonderful way to resolve disputes. I'm going to talk about that a little more in a minute. Collaborative law, also a really nice way to keep your clients out of court, not just in family law cases, by the way, as in mediation, can be used in a number of different types of situations. The big difference being clients sign a participation agreement which says, everybody signs a participation agreement, which says you will not go to court. And that's pretty novel stuff in Tennessee. It is, Nashville has a collaborative law alliance. Shelby County has a collaborative law alliance. Collaborative law has taken off in other parts of the United States and around the world, but is slowly picking up in Tennessee. It's like when mediation started. I don't know if any of you remember. Mediation was viewed negatively at the beginning. People thought it was going to be an extra layer of cost for their clients. They thought that it was going to be, it was not going to work. And now, we all mediate. And in Tennessee, if you have minor children, you have to go to mediation prior to litigating. So I'm hoping that will happen with collaborative law. We have status conferences with the judges. It's a great thing to get scheduling orders. I'm a big believer in scheduling orders. Otherwise, sometimes you have either the other lawyer is delaying things or things just fall by the wayside in our busy lives and practices. So this sort of keeps us on track when we have scheduling orders. Trial, preparation and organization, preparation and organization, preparation and organization. I can't say it enough. You have to have it. Attorney fees, reasonable and necessary, and you have to produce, if you're in trial, you have to produce affidavits from other attorneys that say your fees are reasonable and necessary. That's usually not too hard to get. So, however, we have judges in Shelby County that think many family law attorneys are fees are not reasonable and necessary, and they absolutely will cut them in a heartbeat. So just make sure that they really are reasonable and necessary, and you can look at the statute to see what that means. How long have you been practicing? Do you itemize your bills? Do your bills go out monthly to your clients? There's lots of things you can do to make sure that you don't have a problem with that issue. Post-divorce modifications. Again, these are usually parenting issues, child support issues, move-away issues, or contempt issues. I talked about post-nups, contempt, civil and criminal contempts. Now you have separate hearings. If somebody files a petition for civil and criminal contempt, you're going to have a criminal contempt hearing first, and then you're going to have a civil contempt hearing. Nobody wants to do that. So most of the time now, at least in Shelby County, you will see people just filing for civil contempt. Domestic partnership agreements we talked about. Bankruptcy and divorce, also something you need to be aware of. These issues come up all the time. Child support cannot be bankrupted, alimony cannot be bankrupted, and attorney fees if you have characterized your attorney fees as being necessary for the support and maintenance of a spouse. Now, sometimes you have no choice. You really don't represent the party who is getting the alimony, so you can't characterize your attorney fee like that. And and in those cases, it's pretty easy to get bankrupted out, have your attorney fees bankrupted out. So, the long and short of that discussion is, if you have somebody and you're racking up, and I'm guilty of this, big time, you've got he's shaking his head, $12,000, $15,000 balance owed on an account. What are you going to do? My problem is I happen to care about my clients probably a little more than not so much I shouldn't care about my clients, but I have a bigger heart. I'm better at taking care of my clients than I am being a business person, we'll put it that way. All right, mediation, I've talked about that a little bit. Everybody has opinions about mediation for the most part now. I think most people are on board with it and love it. Styles of mediation, facilitative, evaluative, and transformative. Those are all different. How do you choose your mediators? I'd like to hear from y'all, civil cases too. How do you decide who you're going to go to? Nobody wants to say? Is it a secret? I think that most people will choose based on cost many times, is how expensive. We have some mediators who charge $350 an hour and some mediators who charge $100 an hour in Shelby County. In the particular case, do you want a man or a woman? I think that's a reasonable thing to think about. And how does your mediator mediate? If you're a really good mediator, in my opinion, you can do all three of those styles, depending on what's needed for a particular case. But there's some mediators who will only do an evaluative mediation and only caucus the parties. And there's some mediators who will only keep the parties in the same room. So, I think that's a legitimate reason to decide what mediator you want to use. Also, there's a success rate. Do you ever ask your mediator how many cases they settle? Because it's a good question to ask. And then, of course, choosing your mediator just depends on the facts of the case. I will often talk, when I'm the litigator, I will often talk to opposing counsel and ask for their opinion about what they think. Do you think if somebody's representing, for instance, a husband who is very headstrong and argumentative and trying to think of another not nice word. Anyway, then, that attorney might agree that a mediator who's can control that person might be a good choice. Okay, I put this here because Robert Benjamin was my first trainer in mediation, and he is amazing. I will sing his praises until the day I die. If you ever have an opportunity to take a training from this man, do it. He's in Portland, Oregon right now, but he comes to Tennessee still on occasion, and this is his contact information. He's awesome. So some of these slides that I have come from him, and I think they're, great. Traditional legal communication structure. Attorney talks to their client, the other attorney talks to their client, and there's nobody here, resolving anything. The attorneys talk to each other, and it's cha-ching, cha-ching, cha-ching. You're just paying money. In mediation, it's totally different. The attorneys are on the outside, and the husband and wife and the mediator are in the resolution center. When I did mediations where I kept all the parties in the same room, I used to make the attorney sit in the corner. I don't do that anymore. But from my perspective, that was the client's time to really sit down, talk to each other, and resolve issues. And I found it to be very, very productive. All right, legal myths. When I'm talking to people about mediation as the mediator, you've got to sell them on the process. Number one, they've got to trust you, and you've got to hook them before you can reel them in. So this is one of the charts that I use. If you go to court, there's absolutely no... People think, they have a misconception about what judges do and what they are. We place them on these pedestals, and there's necessarily always a right decision. I put the word right in quotation marks because, there's not necessarily always a right decision in these cases. And you don't know whose standard of fairness the judge is going to agree with. I have clients that come in all the time and go, when the judge hears what I have to say, I'm going to win. That's not necessarily the case, obviously. They also will say, if I'm the mediator, they'll say, look, we've been fighting for 3 years on this divorce. When we go to court, it'll all be over. I just want to go to court. I want it to be done. The problem is, once you go to court, is it always over? No, it's not. There are petitions for contempt. There are appeals. So, it's a flawed reasoning. Is the judge's decision always logical, dispassionate, and unbiased? No, it's not. They're human, just like the rest of us, and they have their biases. And those biases are really important in divorce cases. So, people need to understand that there is absolutely never a certain result. I had a mediation one time where a client said, my lawyer guaranteed me that I would not have to pay more than X dollars in alimony. And I said, really? And he said, yeah. I said, well, we'll just take a break. I want you to, because I was mediating just with the parties and the attorneys were available by phone. And I said, why don't you call your lawyer and see if he'll fax back a letter, a little note that says he guarantees that. Guess what? Never got it. And you know why? Because what lawyer in their right mind would say that or do that? Nobody. But it was shocking to this client. Absolutely shocking. So you have to sort of destroy their erroneous thoughts, I think, about how litigation works. And this, again, objectivity and neutrality, same thing. We think that the judges are above the fray. They're really all part of the system, too. And it is a system. It's called a legal system. So there's really no one who's not a part of the system. Expert witnesses are a part of the system. Lawyers are a part of the system. Guardian ad litems are a part of the system. We could go on and on. Legal standard. When you're in mediation, you don't have to necessarily abide by the legal standard. You can do most of the time what you think is fair. That doesn't mean that you're going to do things that are, illegal or that a court, would absolutely positively never agree to. But you have a lot more ability to craft an agreement that works for your family, and that's huge. Don't have to abide by any mathematical standard. I have people come in and say, I want 50% of the time with my kids and not 1 minute less. And so I have to knock them off that, standard. Not that they won't end up with 50%, but I don't want somebody thinking and coming in thinking that, that's the focus. The focus should be what's going to really work for the family. So you concentrate on what the personal standards are of the parties. And a fair agreement, my definition, actually Robert Benjamin's definition of a fair agreement, is one you can live with. An unfair agreement is one where any person feels exploited. So the focus in mediation is concentrating on what the real problems are, what the real solutions are, not who's at fault. Collaborative divorce. Do I have time? Okay, I'm going to do fast. Who wrote this? Who said that? There you go. And I believe it. I believe it's happening. So collaborative divorce, I think, is the new up-and-coming thing. It'll take some time, but I think we'll get there. Different form of alternative dispute resolution, non-adversarial, respectful team approach. We bring in psychologists. I'm going to skip down to, well, it's not on this thing. I said you agree not to litigate. So if the process becomes hard for people and they think that they're not going to get through it, they can't just walk out the door and run to court and file a petition. It forces them to stay in the process and try to, work harder, try to work something out. We've had psychologists in the room with us. There are communication coaches. There's financial people. It's a great way to get, for everybody to participate in getting things resolved. And ultimately, you still save money. Let's see. Okay, this Collaborative option is great for cases that might otherwise be a big problem in court. It's also interesting because as I've done these cases, I've had to check myself because I tend to fall back into litigator mode, and you don't do that. That's why it's important that if you're going to practice collaborative law and you have an opportunity to take the training, take the training, because it's hard to do. It seems like you just sit in a room and you try to work things out, but it's a different mindset than being a trial lawyer. So you have to be, with your focus is on the family and not so much on your client. I had a case, a collaborative law case, where I represented the father who was transgender. And we were in a collaborative law case, and she was going through the process to become a woman, and ended up actually getting week-to-week parenting time through this process with a psychologist. All these issues were addressed. Perfect case to keep out of court and to keep relationships intact. Uniform Collaborative Law Act. International Academy of Collaborative Professionals exists. Huge organization. Rivals the American Bar Association. Memphis Collaborative Alliance, Middle Tennessee Collaborative Alliance, and I took this right off their website. An organization of lawyers, coaches, facilitators, child specialists, financial professionals who serve divorcing couples and others involved in family law disputes. All right. This is the difference, mediation and collaboration. I don't really need to spend a lot of time on that except for you're always having four-way meetings in the same room in a collaborative case. That doesn't mean you can't meet individually with your client, but when you're having the discussions, you have four-way discussions, or could be more than that if it's a team approach. Parties are safe from the threat of litigation. To me, that's, if I was getting a divorce and I knew nothing about the legal system, that would make me feel good. All right, collaboration and mediation. They're both viable alternatives. Save parties money. Agony protects children. Also can save attorneys from the stress of litigation. I don't know, as I said when I started this discussion, I see more and more attorneys who are not happy with litigating anymore. It's so stressful, and it's just such a negative environment. So we have had some amazing CLEs in Shelby County that had names like peacemakers and holistic law and things like that tend to scare people away. But there were attorneys showing up who've been practicing for 40, 50 years who came in and were, very complimentary of the CLE and could relate to it and actually had a lot to say about how they feel like the system of litigation is so flawed and not a very good way to resolve disputes. Okay, family laws. Disclosure of mental health records is always an issue. Relocating parents, I told you about that. These are brand new, effective July 1st, 2013. Parent disability renders the parent unfit to care for the children. There's a new standard. You have to show that by clear and convincing evidence. This has always been, to some degree, a consideration in custody cases. But look at this down here. This now requires mediators and judges to have training regarding the issues relating to parents with disabilities. That's new. Parents' rights to their children can be terminated if they're convicted of sex trafficking. Duh. Parents' rights can be terminated if the parent was convicted of rape or aggravated rape. Duh. These are cases of first impression. Adult child may recover child support arrearages from the biological father. I don't really have time to get into all of this, but suffice it to say, mom was married. Father paid child support. Father wasn't the biological father, as it turned out. and the adult child tried to collect child support from the biological father once he reached majority age. This case may not be over. It was remanded, and it's a good discussion of the legislative intent of child support and paternity statutes. But right now it's been remanded to the trial court to consider the best interest of the child and the equities between the parties, because the biological father said, hey, I never even got to know this child. Grandparent visitation I talked a little bit about, and then another situation where the father found out he was not the biological father. This is another visitation case. This is a case where parties divorced, got back together, but didn't remarry. Mother tried to collect, there was a child support order from the divorce. The mother tried to collect child support during the reconciliation. The court said, nope, sorry, we're not doing that. And I got to mention this, because this is pretty shocking. It was to me. Facebook. We all know about Facebook, especially in family law and divorce cases. And we all know the problems that Representative Cohen has had with Twitter. So the ABA posted on August 7th, a lawyer in Virginia sanctioned for advising his client to clean up his Facebook page. This was a case where, and he got a 5-year suspension for doing that. Huge. My point being, and what he did was, it was a case where it was a death case, and he told his client to clean up his Facebook page, and they removed about 13. He removed about 13 photographs from his Facebook page, including some that where he was drinking a beer, and some that said, one of them said, you know, I love hot mamas or something like that on there, and they had asked for the defendant had asked for them to produce all that information, and the lawyer told the paralegal to tell the client to get rid of it. So, what? Virginia. It was Virginia. And so my point is, I think we need some more CLEs about this. And that's it. I'm done. Thank you all for listening. Have a great weekend.